Let's talk about pre-trial, before a court ever enters an order. The separation between you and your spouse or you and the other parent has just happened, and suddenly you are without your children overnight, and the other parent is refusing to give you overnight access to your child or children. What do? First, you send text messages and calls, and it's going nowhere. You get a court date that may be weeks or months away, and then you come into my office and you say, Van, I'm not getting the access to my children overnight that I deserve as a parent. But before a court enters an order granting you overnight access to your children, you are in the wild, wild west. There are no statutes that govern this temporary interim period before we enter the court. Sometimes we'll have a temporary or emergency hearing, and in certain instances, you need that emergency hearing to get access to your children. But the courts are flooded with cases, the dockets are very busy, and as often as not, it may be weeks or months before we get back into a court to impose what is rightfully yours as a biological parent. And so what do we do in the interim? Are you going to miss an entire summer or months at a time without your children? It's important to understand the specific facts of your case to give you the right solution. But my job in that situation is to expedite the process, to speed it up, and ensure you are granted access long before the court order ever takes place. So if there are weeks or months before a court enters an order granting you formally that overnight access, it's important to work with a firm that understands the unique challenges that this situation presents and will work carefully together to expedite and quicken that time towards relief. Give us a call, and I look forward to working with you to get what's rightfully yours, overnight access of your children.